Good morning, WTOB listeners. I'm Dylan Greenwood here with Harold Eustache, and this is For the Record with Greenwood Law. And we hope everybody out there listening and watching us had a great Thanksgiving holiday. And of course, with Thanksgiving, following Thanksgiving, we turn our attention to Christmas and the holiday season that's upon us in December. And today we're going to go through a very important topic, Harold.
Mm-hmm.
And it's one I think it's all about perspective. And so I'm going to throw something out there to you. You've got a man, he's dressed in a costume, and he enters into people's homes at night. And he does so without their permission, comes on their property. And based off what I'm describing, you know, you've been a DA too. That'd be a crime, wouldn't it?
It'd be a lot of crimes.
A lot of crimes.
A lot of crimes. So this guy is dressed up. I mean, I think maybe even what he's wearing might be a crime, but what he's dressed up in and, riding on animals on your roof, getting into your,
I didn't even get into
your
that
stuff, could be a lot of crimes. So what we're going to do is just go through, what some of these crimes could be, and how we would address them. And like you said, it's all about perspective. I mean, one perspective is, he's there to do good. Another perspective is, man, he's breaking a lot of laws in North Carolina. So,
of course, we're talking about Santa Claus.
Right.
And what we're going to talk about, what Harold's getting at is that, all the things that Santa Claus does, how those could be violations of the law here in North Carolina. But it also helps us talk a little bit about our job as defense attorneys, because what we run into quite a bit is we hear one side of a story. Usually we start off and we hear one side of the story from the people that call us. Then we hear one side of the story from the police officer, the district attorney, whoever's a probation officer, whoever's involved. And so everyone, not just us, but defense attorneys, DAs, judges, everyone's trying to sift through to figure out, based off all these different sides of a story, what's going on.
And one of the interesting things that we know, not to get too much off track on this, but one of the interesting things that we know is people can watch the same thing or see the same thing and still come out with a different view of what happened, of what the truth is. And that's...
I feel like I go through that at least once a week.
No doubt.
I mean, no joke. Sometimes you're watching something or you're reading something and, someone else is telling you their interpretation of it or what they're seeing, and you look at them and you go, are we watching the same thing?
Right. And that's the interesting thing about the law, and that what we have to tell people all the time as defense attorneys, it's about perspective. Yeah. And it's also about the perspective of the fact finders, of the people that are making the decision about what the facts are or aren't, be it a judge or a jury. So we're going to go through some of this. I think there's an obvious one here that everybody's probably that understands, but there's some crimes here that people would be shocked about.
Definitely some nuances.
So one of the first ones is Santa's got to travel.
He does.
So, and he's got to get there really fast. So can you talk about, what may be one of the criminal violations?
If Santa's sleigh were to touch some sort of public street or highway in the state of North Carolina, he would be subject to the same laws that you and I would be driving on the road. So I don't know, maybe things that I don't know about Santa Claus, maybe he has a license. But if he doesn't, as soon as he touches a road on North Carolina soil, he would be driving without a license.
He would be. One of the interesting things about driving without a license that is a nuance is that it's on a highway, a street or highway, that you can be cited for driving without a license, but not a public vehicular area. Maybe I think we've talked about public vehicular areas when we talk about DWIs a little bit, but it's important to note the difference. Public vehicular area could be some small side parking lot that's not a street, but you wouldn't necessarily get you shouldn't get a driving while license.
Typically it's parking lots.
Right, parking lots.
Yeah.
You shouldn't be able to get a driving while license revoked in a parking lot as opposed to a street or highway. But he could also be cited for
speeding
or reckless driving.
Reckless driving.
So can you explain, I know reckless driving is something that's cited a lot. Can you explain what that is to our viewers?
I think a lot of people, at least people I talk to, about traffic stuff are blown away when they find out that they've been cited with reckless driving, that's a Class 2 misdemeanor.
Right.
It's a more serious misdemeanor than many drug possession charges. It is the same class level as carrying a concealed weapon.
As a simple assault. As punching someone in the
face. As a simple assault.
Yep.
You're exactly right. I mean, sometimes it blows your mind that it's on that same level, especially because sometimes it feels like reckless driving is just sort of handed out alongside a high-speed ticket.
It is.
Which, to some degree, I get, especially if you're going at a really, really high enough speed. But there are some counties and some states that I'm aware of that if you're going 15 miles an hour or over the speed limit, it's just automatic reckless. And, that's a pretty tough thing when they're all of a sudden, they've never had a substantive criminal history before, and then all of a sudden are subjected to the possibility of a Class 2 misdemeanor. And people have a hard time wrapping their minds around that. But, it carries with it up to $1,000 fine and up to 30 days in jail. And that is pretty tough consequences. And I've seen people get jail time for reckless driving before.
I have too. And a lot of times, if you think about it, everybody drives on some level, and you think about that person on the highway that flies past you at 100 miles an hour, and you're like, man, can't that person get a ticket? That, if they did get cited, a lot of times that's the person that's reckless driving. That's what it's going to be seen as. Of course, it can be other types of erratic driving. There are, I guess one of the things is there are, with reckless driving, it's a broad statute, and there are other statutes for things like driving the wrong way or making, lane changes that are wrong. So you do see it cited kind of for speeding most of the time. And it can be serious. It can be serious and have serious effects on your insurance and license points and all sorts of stuff.
Right.
So,
I mean, the other thing, obviously, we talk about a lot on this program, a lot of people leave out milk and cookies for Santa. Some leave out eggnog. Well, if any of that's got a little something extra in it.
A little extra sauce in it.
Yeah, that secret sauce for Santa Claus, because he's got a long night. And let's say, he has too much of that, obviously subjected to the laws of driving while impaired here in North Carolina. And those, as we've talked about plenty of times, are very strict, depending upon the levels to which, what someone blows, whether they are driving in a reckless manner, all these different things could add and amp up a level of a DWI that could have very serious consequences for somebody. So
it could. I mean, and of course, DWIs, whether there's extra sauce in there from alcohol, but DWIs can also be from drugs, as we know. And so, it's taken very seriously in North Carolina. There's a whole separate sentencing structure for DWIs in North Carolina. So
and it's not just illicit drugs.
Right. That's important to point out.
I think it's really, really, I don't know how many times people call us up and say, well, I was prescribed Ambien. I was prescribed, this pain medication. There are a lot of times that those prescription bottles say, do not drive while consuming this drug or while under the influence of this drug. The reason why is because you are impaired when you do. And it's important to be able to, recognize when that happens. So let's say, Santa's been hauling that bag around and he's got a little lower back pain and, he takes something for it, that could subject him to these laws if it were an impairing substance. Typically taking an Advil or Tylenol, whatever, that's not going to do anything to you. But, things like Oxycontin, hydrocodone, sure. Any of the amphetamines, stuff like that, definitely can affect you and alter your state to where you're not the same driver out on the road. But the important thing is, he's got to touch the road.
Got to touch the road.
So our recommendation to Santa, keep it high.
And another thing is, it's got to be in a vehicle.
It does.
And so can you talk about whether or not a horse and buggy could be?
So one of the things that we frequently do as lawyers is we try to see or look for places in the law or case law that are similar to something that we're dealing with, because no statute, no amount of case law can come up with everything that we see. And I'm just going to tell you, we hear and see crazy stuff. That's one of the reasons why I love doing this job. It's always entertaining.
Every day.
Like, it's great. We get to see a lot of interesting stuff. For that reason, the way the judicial system approaches the law is that you try to find places in the law that are similar to what you're dealing with. Well, Santa's got a sleigh and he's got reindeer. Obviously, in the state of North Carolina, that's not a common setup for people out on the road. It might be up in, like Alaska or Norway or parts of Canada, but not here because we just don't have enough snow, right? But we do have horse and buggy that throughout our history were used, and some people still use that. It's taking the hay rides that you go on, or people with farms in rural areas. You're exactly right, and those are subject to the same DWI laws as automobiles.
They are. So it's important to note, you can get a DWI horse and buggy, you can get a DWI on a bicycle, on a certain types of lawnmowers, if you're on a golf carts. It's expansive, and we won't go too much into that. But another thing is that Santa, he also has animals, right? He reindeer,
does.
And that could subject him to criminal liability too.
That's exactly right, because he's going all day, all around the world. He is circumnavigating the planet, delivering gifts, literally working 24 hours. And the animal cruelty statute in North Carolina, you think about it, if he's starting all the way on the other side of the world, in Guam or Japan or somewhere like that, by the time he gets to North Carolina, you would think these reindeer are going to be tired. And that's why you leave carrots out for the reindeer, but still, they've been hauling all this stuff all around the world. And in the state of North Carolina, it is a violation of the animal cruelty law if someone intentionally overdrives, overloads, wounds, injures, torments, kills, deprives of necessary substance to any animal. So I think overdriving, overworking could possibly be, depending on how you look at it, again, a mean prosecutor might say, Santa Claus, you're overworking these reindeer, man. You got to give them a break.
There's no doubt that animal cruelty statutes are taken very, very seriously. I actually did CLE when I was a DA with the Conference of DAs on animal cruelty, and was one, taken aback by how serious some of the cases are in North Carolina, but two, it's something that prosecutors take seriously and that I think all citizens take seriously. So, you can have, because, we do use animals for work, and especially in rural parts of the state. And if you're overworking an animal or overdriving an animal, you could be charged with some sort of criminal offense for that. We've talked a little bit on the show about animal cruelty and tormenting animals and stuff like that, but even overworking them for some reason, it's hard to see you overworking a dog for whatever reason, but that would probably go into tormenting on some level.
Right.
But for those types of reindeer or donkeys or horses, that could be very, very applicable to that statute. And it's a pretty broad statute. And I think, again, prosecutors take it seriously, even though it's a class 1 misdemeanor. There are a lot of judges that will make you, serve every day of it.
Absolutely. And that can be up to 120 days in jail plus a fine. So, it's very serious in and of itself, just like you said. I think one of the more obvious ones here is that Santa could subject himself to is trespassing. Now, I think this has got a lot of nuances because trespassing is defined as entering the private property of a landowner or a legally permissible occupant without their permission or by violating clear signage that says no trespassing. So I guess for Santa Claus, it really comes down to whether or not he had permission. So if the gate's locked out front, the door's locked, those
Chimney
things.
chute's closed.
I think the chimney chute being closed would be a big indicator that maybe
we don't want Santa in. Right?
He's not welcome to come in.
Right.
And could be one of those facts that goes against Santa for trespassing.
And an important thing to remember about, I was talking about trespassing with someone recently, and one of the important things to remember about trespassing is it is up to the rightful occupant of that place to determine whether or not someone's trespassing. So if they give someone permission to be there, then they're not going to be trespassing. But if they don't give that permission or somehow withdraw that permission, so someone could be there, someone could be Santa could be at your house, and you say, you know what, Santa, I want you to leave.
Is there a
at
difference?
That point,
is there a difference between the adults and the kids?
I do. That is an important question that we actually have dealt with in the criminal law about implied consent, or I'm sorry, implied consent, but consent given or authority given from someone else that's not the main owner. And is that authority justified? So if a young kid comes in and the kid says, it's okay for you to be here, Santa, and the adult finds out later and says, no, it wasn't permissible, that could Santa be charged or not? I know that to our viewers that might sound like really getting into the weeds, but that is the kind of stuff that we deal with as defense attorneys.
It comes up
all the time.
Most frequently in Fourth Amendment search cases.
Right.
Where maybe somebody borrowed a car, or they're temporarily living at someone else's house, or maybe even just staying the night, and the person who owns that or rents that house is away. Does that person who's temporarily there all of a sudden have the right to give authority for someone to search or come in law enforcement wise? And I mean, that happens more than you think. Right.
And it goes down to, was it reasonable for that person to believe that this person had the authority to could give them the authority to be there? But I think that's an important question for us, legally with regard to trespass is important, because trespass can happen so many different ways. We see it happening in private settings in people's homes or businesses or small businesses, but we see it a lot, of course, in a retail sense, especially around the holidays, where big companies like Walmart, Target, Belk, or whoever, they ban people, from their stores for various behavior. And they don't have to have a really big reason to ban people. They can ban you for whatever reason they want as a private employer or as a private entity. And if you violate that, it can become trespassing.
And it's a more serious form of trespassing, because if you've been given
two types of
notice in that way before, and I'm not talking like a trespassing sign, a no trespassing sign, but if you've talked to somebody on the premises and they said, don't you ever come back here, you're banned from these premises, then you're on a different level of notice, and the law takes that into account and gives you a higher penalty.
Yes.
If all of a sudden it becomes a class 1 misdemeanor for that level of trespassing because you've been notified before.
Right.
And that's a way more serious charge, because normally trespassing isn't all that serious. A lot of times on trespassing, those kinds of cases can get worked out because you can go to somebody and say, listen, they promised never to come back, and that really what you want and all this. And typically it works out well for everybody. A lot of times it's a misunderstanding, really. But if Santa goes down that chimney and the parents come out and they say, Santa, don't you ever come back here, and then next year he's coming bringing toys, then that's a higher level of misdemeanor he's subject to.
It is. If you're just joining us, WTOB listeners, this is For the Record with Greenwood Law. I'm Harold Eustache along with Dylan Greenwood. And this morning we are talking about Santa Claus and all the different criminal violations that he's racking up during the Christmas holiday, coming to your home. And we've talked about several, but there's a couple of them that are, I think, more obvious and kind of interesting for us to kind of get into. So one of them is, Santa has to get onto your house and he has to touch your house. And, a bunch of reindeer landing on your roof
in a big
several
sleigh.
thousand pounds and several 1,000-pound sleigh could do a lot of damage. So what happens if somebody does damage to a roof or any other part of your house?
So that's an injury to real property issue. in North Carolina. It's a violation. It's a misdemeanor typically. It's a class 1 misdemeanor for injuring somebody's property, and you can face a maximum of 120 days in jail for it. So it could be as simple as knocking a shingle off the roof all the way up to, leaving skid marks from the sleigh on the roof. However that real property is injured in some way, and it's not just outside the home, it's inside the home too. So, Santa's got to get down that chimney. And when he gets in the home, let's say he accidentally knocks something over, that could be, depending upon what happens with that object. Mm-hmm. If it were to knock a hole in the drywall or scuff the paint, it's an injury real property issue.
And for our viewers, I know this is one of those things in law school we talk about, but real property versus personal property. Mm-hmm. What does that mean? Because there's two types of injuries in the criminal law, one personal and one real. And so for our viewers, if it's affixed to the ground, it's a building, that's the real property. And so even parts of that building that are affixed to the ground, like the roof, is still real property of a building or home. And that's broken. But if he comes into your house and knocks something over,
the object's inside.
The object's inside.
Those are personal pieces of personal property.
Are personal property. But he could technically use personal property to injure real property. So there could be a lot of weird mm-hmm. things going on there. But it's important with real property too. And a lot of times we see this in stuff like doors is mm-hmm. the most common way we see this. Windows. Somebody breaks a window. A lot of times with the doors things, this happen in domestic situations a lot. It's one of the things that, the first thing that the defense attorney's mind goes to, I think anybody in criminal law, is when you see those types of charges, you think of domestic stuff because people kick doors in or injure doors in domestic disputes. So that's when we see them the most.
I don't know how many cases I've had that have revolved around repairing or replacing a door.
Right.
I can't tell you how much that comes up. And then probably second to that are windows. Mm-hmm. Doors 1A, 1B windows. Yep. It's crazy. And then 1C would be windshields.
Right.
Yeah. And I'm sure you can imagine all the reasons why a windshield might get knocked out.
Many reasons. Yep.
Yeah.
So that's what we see a lot in those injury cases. And a lot of those cases are, there needs to be a dollar amount, assigned to those mm-hmm. cases when it's charged. And a lot of times those cases are worked out, not all the time, but a lot of times that they're worked out between the two parties where, if you can make somebody whole and pay whatever restitution there is, it could be something that goes away. But it is one of those charges, again, that we think about with domestic situations.
Yeah,
but
absolutely.
It's certainly something that, somebody, putting something on your home that heavy could definitely get that kind of charge. Another one is Santa's he's got to get into your house.
He sure does. And that's a breaking and entering issue. It's important to note it's not a burglary issue. To commit burglary in North Carolina, typically anywhere, it's breaking into a home at night for the express intention to commit a felony inside. So, he's broken into your home. It's at night, but the big argument in Santa Claus's favor is that he's there to leave you presents and to eat some cookies you left out. Neither one of those are a felonious act. So the only way it would be felonious would be like, let's say there's a big 60-inch TV on the wall that mm-hmm. Santa really likes and he decides to take it off the wall and wants to steal it, then that would absolutely be burglary. But just leaving the presents, just eating cookies, it's a breaking and entering issue, not a burglary issue. The other key distinction is that, in my opinion, it would probably be a misdemeanor breaking and entering version of it, and not a felony version of it, Harold.
I think so too.
And the reason for that is because the felony version of breaking and entering requires some sort of force in the breaking and entering itself, whereas the misdemeanor version is usually like going in an unlocked door.
Right.
something like that, or an open window. And so in Santa's case, the times in which he's just going down the chimney, that's not a forcible entry issue.
Right. And sometimes we see misdemeanor breaking and entering all sorts of various ways. But, one of the ways that first comes to my mind is a case that I have. I'm not going to explain everything about the case, but just that it was an open door and it was a domestic situation. And a person wasn't necessarily supposed to be at the house at the time, kind of boyfriend, girlfriend that were, close, but then we're not close, and walks in the door. That's a breaking and entering, and it's not supposed to be there. So it's, I know for some of our listeners and viewers, they may think of it as, the person's got a crowbar, they're just prying their way in. That's not always what breaking and entering is. In fact, a lot of times it's not.
Yep.
It's not.
Well, WTOB listeners, we really appreciate you joining us here on For the Record with Greenwood Law, as we've kind of broken down all the ways that Santa Claus unfortunately could be a criminal. I know that the mounted police up in Central Park in New York, they've been after him for years, according to Elf. But if it were me, I'd represent Santa Claus pro bono. What about you?
Yeah,
Harold?
man, absolutely.
Yeah, I think we could get him out of whatever we've talked about today. Before we go this morning, though, don't forget that Greenwood Law Bill of Rights, and that's first and foremost, I will not represent myself in a court of law. 2, I will not do law enforcement's job for them. 3, I will not make statements when stopped by law enforcement. 4, I will not consent to searches when stopped by law enforcement. And 5, I will not be my own star witness for the prosecution. Everyone stay safe out there. Enjoy this holiday season. And this is For the Record with Greenwood Law signing off.